If you live in Canada, there's a good chance you've noticed the nationwide growth in the number of homeless encampments in recent years. The birth of these new encampments has been linked to a myriad of factors that include the pains of the COVID-19 pandemic, the modern cost of living crisis, and a rough housing market. Although some local governments have responded to homeless encampments by, removing them, others have adopted a more passive strategy of non-intervention. One of Canada's many homeless encampments can be found in Kitchener, Ontario, where, in December 2021, a homeless encampment was born at 100 Victoria Street North, atop property owned by the regional municipality of Waterloo. In the coming months, the encampment would swell to shelter dozens of people, and Waterloo's attempt to dismantle this encampment not only reveals conflicting notions of what the shelter system provides, but may also set a precedent for how homeless encampments and the homeless population can be treated by governments in Canada. Following the encampment's conception in late 2021, it grew in both population and infrastructure, such that by the summer of 2022, the encampment was home to around 50 residents, who were provisioned with tables, barbecues, and chairs, and were being supplied by outreach workers with necessities like food and clothing. The regional government was well aware of the encampment's growth, and in fact hired private security to monitor it in March 2022. And although the government was more accepting of the encampment when it was small, its increasing size changed that passivity. Now, glossing over a bit for simplicity, in June 2022, the regional government made moves to evict the encampment and its residents, having undertaken risk assessments back in May that arrived at the conclusion that the encampment was a risk for local health and safety for the encampment residents and for the community at large. So, it set up signs at the encampment in early June that informed encampment residents they must depart by June 30th. Perhaps unsurprisingly, the encampment remained in place at the end of the month. The regional government, seeing the encampment remain, announced it would seek guidance from the Ontario Superior Court of Justice for assistance in how it should evict encampment residents. As although the regional government recognized its authority to remove the encampment, it also wanted a precedent to be set for future encampment removals. In the meantime, though, the encampment and its residents were able to stay. The regional government asserted in an application to the court that the encampment residents were in violation of a local bylaw on public property usage. Essentially, the government wanted the court to provide guidance on how to execute its legal right to evict, and for the court to affirm that the homeless encampment and its residents were indeed violating the law in the first place. The hearing on the encampment and its fate began on November 7, 2022, kickstarting a case known as the Regional Municipality of Waterloo v. Persons Unknown and to be Ascertained. Now, rather than focusing on the bylaw itself, the lawyers representing the Victoria Street encampment residents reframed the case as one of charter rights and a person's ability to take shelter. They asserted that evicting residents from the encampment would constitute a violation of their rights provided under the Charter of Rights and Freedoms, and that the application of the regional government's bylaw violated residents' Section 7 charter rights, or their right to life, liberty, and security of person. They insisted that the local shelter system didn't realistically have enough space to accommodate the region's entire homeless population, suggesting that while many shelter spaces may appear accessible for homeless individuals, they can be rife with barriers that exclude would-be homeless shelter users, such as how one local shelter didn't accept men, or how another shelter may appear open on paper but be under construction in reality. For their part, the government disagreed with basically all of that, and advanced the position that charter rights were irrelevant to this case, as they considered this scenario to focus on property rights instead. And they argued that there was indeed sufficient space in the local shelter system to accommodate all the encampment residents with, shelter, without them needing to erect shacks and tents in a gravel lot somewhere. The case reached its conclusion the following year, and on January 27, 2023, the court ruled in favor of the encampment residents. In his decision, Justice Valente noted an appreciation for how evicting homeless encampments comes with notable health perils, as being evicted from an encampment disrupts former residents' access to healthcare, puts them at risk of exposure-related dangers like frostbite, can worsen mental health issues like a person's PTSD, and can lead to increased substance usage and overdoses. The justice also found that there were still insufficient shelter beds to accommodate the region's entire homeless population, arriving at the conclusion that although the regional government has indeed attempted to better accommodate their homeless population, the region still only possessed around half of the shelter capacity that would be required to service all homeless individuals in the area. The justice also found that the accessibility of shelter spaces was important, and that when shelters do not suit homeless people, be it for reasons like couple accommodation or if a shelter is unwelcoming to those with addictions, then the space isn't actually accessible for them after all. Finally, the justice ruled that one's ability to create shelter is protected by Section 7 of the Charter of Rights and Freedoms, as it is considered part of a person's right to life. noting that a lack of proper shelter can imperil a person, including to the risk of death. And that precisely because the regional government's bylaw was attempting to prevent the creation of shelter that protected the homeless from peril, and the region lacked the shelter beds to accommodate the whole homeless population, the bylaw thus violated a person's right to life under the Charter, and that this infringement was not justifiable under Section 1 of the Charter. This ruling effectively prevented the eviction of those living at the 100 Victoria encampment, at least so long as the shelter system cannot accommodate the entire homeless population, completely contrary to the original desire of the regional government. This outcome constituted a first for Ontario, as it was the first case here where a homeless encampment clearance was deemed to be a violation of homeless people's charter rights. And its ruling may set an important precedent for how homeless encampments can be treated within the shelter system. For example, following the case's conclusion, Professor Esther Van Wagner of Osgoode Hall Law School opined how the case's outcome leaves the City of Toronto quite vulnerable regarding a future legal challenge on the subject. And following the case ruling, Waterloo announced that it would not seek an appeal to Valente's decision, allowing the encampment to survive as an informal home for the homeless. The Waterloo v. Persons Unknown case is a fascinating dispute that isn't quite like the others this channel has examined. It's a case where a government brought an issue to court only to be defeated in an upset victory for the homeless. It's a case that arguably takes the first step towards creating an honest-to-goodness right to housing in Canada. And because the case is so recent, the exact impact of the ruling has yet to be determined. Maybe Waterloo v. Persons Unknown will end up like R v. Big M and make big change from humble beginnings. Or maybe Waterloo v. Persons Unknown will be a flash in the pan that goes precisely nowhere. I won't pretend to know how Waterloo v. Persons Unknown will be used in the future. This case is so fresh that, to my knowledge, it has barely been considered by legal academics. I look forward to finding out what they think. And more importantly, I await what will come of this Kitchener eviction ruling. Thank you for watching. Please like, share, and subscribe for more loving videos about Canadian issues. Have a good one.